Welcome to the part 3 of chapter 5 from the Modern Indian History lecture series on the Bipin Chandra. So, in this lecture, we are going to talk about all the judicial organization that was taken at the time. So, the civil code, the criminal appellate code, all those things came during this period. Okay, so introduced by the Cornwallis, and at the time you will see that judicial not supremacy, that's the separate thing. So judicial court will come where they will start to break the old Indians or old religious laws. So there were some cruel punishment at the time uh, based upon the Sharia laws and all. Okay, so just they came up with their own that they came up with the judicial organization, that the judicial uh, supremacy or organization kind of stuff they presented, and they started to follow the rule of law. Okay, rule of law. Okay, so before moving to this lecture, I will request you to please like and subscribe. This is a new channel. We really need your support. So the British laid the foundation of a new system of dispensing justice through a hierarchy of civil and criminal codes. So what they have done, they divided the court into two things. One was civil, and another was your criminal code. Okay, another was your criminal code, and it was like started by the Warren Hastings, but implemented by the that established was done by the Cornwallis in the 1793. So now make sure like this is little bit more division part of things, how the court was divided, so you have to pay more attention here. So each district's diwani adalat or civil court presided by the district judge who belong to the civil services. Okay, so the each district president were there, they will have one civil court presided by the district judge, or in Hindi they used to call it as a diwani adalat or civil court. Thus, Cornwallis separated the post of what civil judge and the collectorate, because the corruption was there and civil services was connected with that. So, to make the post independent, Cornwallis separated the post of civil judge and collectorate, district collector. Below the district court were your registrar courts headed by the Europeans and a number of subordinate courts headed by the Indian judges known as munsifs and the amins. So these munsifs and amins used to take with the petty cases and the small cases for that. Okay, and if there is issues with the more at a seniority level, so the Europeans and all at the registrar court will handle it. To deal with the criminal cases, this was a civil case code. Now, to deal with the criminal cases, Cornwallis divided the presidencies of Bengal into four provinces. Okay, they divided the presidency of Bengal into four provinces to deal with the criminal case at a higher level. So, in each court of in each like court of circuit was present, presided by civil servants. Civil servant exam and civil services, the first pillar. Don't know whether it is the first pillar only. There are three pillars introduced: civil services, army, and the police. Okay, among that, civil service was one of the pillar introduced by the Cornwallis. Below these courts, large number of Indian magistrates presided to try petty cases. Okay, so earlier how it was being handled. Now judicial organization being introduced. Now, so what was the earlier administrative workout. So it was like these cases were used to be looked by the jamindars at the time, and the petty cases like he used to take handle all those cases. Their power were given to them. So rich were became poor were unable to cope up at the higher level, and it has to be deal with at jamindar level only. So the old system of justice was very simple, as jamindar decided all petty cases, and this was open to abuse and gave enough scope for rich to oppress poor. Okay, so see one thing, if you see uh, the law, whatever the law or the organization you are seeing here, it will look like that it is good. Okay, it will look like it is good. What is wrong in that? Okay, because rich was being like poor was being oppressed by the richer jamindar, and the punishment that was present, like tearing of limbs present in the Muslims and all Sharia's laws. Even in the Hindu there were like satis, and also there were lots of that kind of have like heinous punishment kind of things was present at the time. Okay, so if we see, we'll see that okay, these laws that are being implemented are good in nature. So just mark one point: maximum law, anything that comes into play, that always come with a good in intention. Okay, intention always will be good, but the implementation is the main part. In what manner it is being implemented? Even if you see the government, whenever the government comes, it will come up with the new policies, and in each policies you will get to know something good about that. So government comes, always comes. So whoever saw the government, opposition, the Congress come, even if the BJP come, or the third party, whoever will come, they always come with the policies with a good in intention. Problem is the implementation part. Okay, the same thing is being discussed here. Okay, so the whatever the thing is being implemented is just to overcome the old practices, to overcome those things. But actually, is it going to be implemented in that way? No. Even after that, there will be discrimination against the Indian people. Okay, so to check those abuses, judicial organization was being implemented. Hastings set upon himself to reform the judicial system. He established two courts in each district. How many courts? Two courts. Diwani. What about two courts? Civil and criminal process. Only these two options are there. So the Diwani Adalat to decide the civil cases. Which court for the civil cases? Diwani Adalat. And for criminal cases, Faujdari Adalat. For the criminal cases, Faujdari Adalat. Okay. Two courts: Diwani Adalat, Faujdari Adalat. Diwani Adalat, civil cases; Faujdari Adalat, criminal cases. In Diwali Adalat, the collector was to be presided, assisted by the native Diwan. Okay, so that local, they will have a control of the local people. They will go get to know the local cases. Faujdari Adalat was presided over by the Kaji or the Mufti of the district, and two Maulvis subjected to the supervision of the collector. So, in addition to these, two superior court. Okay, so now Diwani Adalat, Faujdari Adalat will come. Now, two superior court will be there that established at Calcutta. One was the Sadar Diwani Adalat, Sadar Diwani, see, Diwani Adalat, Superior, Sadar Diwani Adalat as a court of appeal in the civil cases, and Faujdari Adalat, superior to it, Sadar Nijamat Adalat, to hear the criminal cases. So these criminal codes applied Muslim criminal cause in a modified and less harsh form. So there was one of the punishment that is given in the book. It is like the tearing apart of the limbs if you are doing some kind different kind of punishment. So these kind of punishments were banned, and these things will be handled by the judicial things. Whatever the law or things will present, as per that punishment will be given. Okay. So the role of William Bentinck. Who is the William Bentinck? Was the first Governor General of the British occupied India. Remember, we have discussed those things, I think, in the chapter 4. So everyone else before him was the Governor of Bengal, and he, after that, when this post came, Governor General, he became the first one, William Bentinck. So on his return, England, Bentinck served in the House of Commons for some years, being appointed Governor General of Bengal in 1828. So Bentinck raised the power of Indians in the judicial service and appointed them. So for the Indians, he raised some people, officials, and appointed Indians as the deputy magistrates, subordinate judges, and the principals as the amins. So in 1865, high courts were established at Calcutta, Madras, and Bombay. So three presidencies we know at that time. After that, centralization came, where the Calcutta became the center, and there were the offices present at Madras, Bombay, and Calcutta. But they remove those higher posts of the Madras and Bombay, and they make the administration capital at the Calcutta. Okay, remember those things. So the 1865 high courts were established at Calcutta, Madras, and Bombay to replace the southern court of Diwani and Nijamat. So the British gradually evolved the system of new law, and they replaced the old customary laws based on the Shastra and the Sharia. So whatever the laws were present as Shastra, they replaced it, and it was like modern laws punishment will come to go with any judicial formation, that still we are following it. So there were issues also present at the time. The number of cases were high. The cases used to take lots of time. The fees of the lawyers were very huge. And today also these are the same themes. We have a lots of pending cases. Reaching to the court is difficult. The fees is difficult. But yes, government provides the lawyers and all. So these are separate cases. But yes, there are lots of pending cases present with the courts. Okay, and there is a even the posts are vacant. So judicial supremacy kind of things, and the collegium system, appointment of the judges, and also that's a separate topic. So they codified the law and they modernized them with the judicial interpretation. The people were bound to follow the law blindly. Shastra and Shari, they don't question what is the reason behind it. So so they came with the judicial organization and to overcome these things. So how was judicially unified? How they unified? There were separate laws for the Indian based on Shastra. There were separate laws for the Muslims based on the Shariat laws. Now, through these common law, they unified. That's it's calling as judicial unification. So in 1833, the government appointed a law commission headed by Lord Macaulay to codify the Indian laws. Its labor eventually resulted in Indian Penal Code, the Western derived for the Code of Civil and Criminal Procedures and other codes of laws. The same laws now prevailed all over the country and they were enforced by a uniform system of courts. So two things came: the rule of law, equality before law. That it comes in our fundamental right as well. And rule of law, that's due process of law is being followed by the USA, and this England was based on the rule of law that we have, that we also follow as part of the constitution. So the British introduced the modern concept of the rule of law. It means what it means. It means, like, let us suppose you have committed a crime. You have committed a crime. Now this case went to the court. Okay, now what court will do? Court will see whether do we have a provision for that particular crime or not. Okay, if there is a provision for that particular crime with us, then what is the punishment for that? If it is written, as per that, judge will give decision. Now let us suppose a scene where that particular crime is not mentioned somewhere anywhere else. Now judge will give a clean sheet, or it depends upon the decision, because there is no rule of law is being written about that thing. Ultimately judge will not give a punishment on that basis. So that's something called as the following rule of law. What the law is written, that will be followed. Even if you remember the Nirbhaya case that happened, where when one conviction, one convicted person was less than the 18 years of age, and due to the 18 less than 18 years of age, it was not given a death penalty for them. But after that the court was the law changed, and where the if the heinous crime is convicted by the even less than the 18 years or the age like that, they could be like they could be hanged till that kind of punishment, that death punishment could be given. Okay, so that's another case. So it means, like, just we will follow the rule of law. If it is written in our constitution, we'll follow it. If it is not, we'll not follow it. We are just following the rule of law. So that kind of things present, and we are following that, the rule of law. So the British introduced the concept of rule of law. So it means administration was to be carried out, at least in theory, in obedience to the law. Whether it was being practiced at the ground or not at that time, we don't know. We knew, like, it was not followed. There was a discrimination present between the Indian conviction and the British people conviction. Okay, so in practice, of course, the bureaucracy and the police enjoyed the arbitrary powers and inferred with the right and liberties of the people. Earlier, in the previous rulers, they used to act on their will, and nobody was responsible to question on their action. Now judicial supremacy is present. Supreme Court will come. If you are not following the law, Supreme Court will come. Okay, even at the constitution amendment, if you see there is a law, if they are checking with the basic structure of the constitution, if it is being tampered, judicial supremacy is there, they will come and they will struck it down. Okay, so that kind of thing is mentioned. So the rule of law made like these things we followed in our constitution, and we are following it because it was a good thing. That's what B.R. Ambedkar said. B.R. Ambedkar was there was a point against him that why you have followed the British thing. So he said that if anything is good, something is there. There is no there should not be any doubt in like accepting those good views. Okay, so that's what the rule of law was accepted through there. So the rule of law made obviously by the foreign people in the favor of them uh, are not through democratic leeway. For that period, the great deal of power lied in the hands of civil servants and the police. So equality before law, everyone is equal before the law, even if you are irrespective of any discrimination. But that was not being followed at that time. Today it is followed. It is present in our fundamental rights. Okay, so the Indian legal system under the British was based on the concept of equality before law. Same law, irrespective of caste, creed, group, religion, or class, will be followed. But the Europeans and their descendants had a separate laws and code, and in criminal cases can be tried only by the European judges. Further, they treat Indians with haughty, harsh, and the brutal manner. So they discriminate the people on the basis of uh, regionality. So Indian were treated in different manner and the British were people in different manner. So justice became quite expensive. Even today is expensive. What in the case of expensive? In the scene of time as well. The cases are pending more than 10 years, 5 years like that. Cases are pending and they get the time for one single hearing after 2 years like that. It used to happen. So justice became quite expensive due to fees of laws and expenses of witness met. Further, it took longer days to close the cases. Even today it is there. Courts were often met at distant towns. The complicated laws were beyond the grasp of illiterate and ignorant peasants. Further, rich used to twist the laws and used to make operate courts to their favor. Twisting of laws. That's what the work of lawyer is there, that they play with the laws, that they point the law, that this is the law, this is the law, I am following that law, what is the reason behind it, why you are making such kind of judgment. So this point is wrong. So it is like just a twisting the laws. If it is something is codified, so they will pick it there and they will play around that. So moreover, the widespread prevalence of the corruption in the ranks of police and the rest of administrative machinery led to the denial of justice for the people. So these were on the theoretical ground, these were good, and still we are following it. But at the time, it was not that, it didn't went into the favor of Indian people. Okay. So in the next lecture, we'll proceed with the social and cultural policy. I hope you have liked this video. Please like and subscribe. This is a new channel. We really need your support. If you have any doubt, please feel free to ping on my Twitter handle or on the comment section. Thank you.